Spouses may, by contract of succession, appoint each other as one sole heir in the event of the demise of the other. You may believe you're financially secure despite the martial crisis and upcoming divorce. Really? You may be lulling yourself into a false sense of security. What consequences do pending divorce proceedings have? Watch this video to learn more. My name is Tamara Freiner. I am an independent attorney at law in the Canton of Zurich, Switzerland. If this video appeals to you, please like it and forward it to someone else. Divorced spouses have no statutory right of inheritance in relation to each other. So far, so good. In the past, this could tempt people to delay a divorce to be divorced by death from a seriously ill spouse. Now, the legislator has decided that when a divorce proceeding is pending, the critical point in time is moved forward on the timeline. Even during pending divorce or dissolution proceedings, forced heirship of the surviving spouse or partner may be avoided. What does that mean? If someone is not entitled to a compulsory portion, he or she can be skipped in full by testamentary disposition. Someone may not only be passed over, pending divorce or dissolution proceedings may have further consequences. Inheritance law and marital property law benefits will cease. You have heard correctly. By law, according to Article 120, Paragraph 3 of the Swiss Civil Code, spouses or registered partners may not raise any claims based on testamentary dispositions, for instance a will or a contract of inheritance, after the demise of a spouse or registered partner during a divorce or dissolution proceeding, unless there is an instruction to the contrary. In other words, the binding effect of inheritance contract ceases by operation of law. Thus, each spouse can dispose otherwise despite pre-existing contract of succession. In the example mentioned at the beginning, both spouses have concluded a contract of inheritance. They undertook to appoint each other as one sole heir in the event of death of the other. Should one spouse pass away during a divorce instigated by joint request or continued by joint request, or the spouses have lived apart for at least 2 years, the other spouse may not lodge a claim based on the contract of succession. The appointment as one sole heir has lapsed by law. However, if the deceased spouse did not make a holographic will and did not deprive the other spouse of its compulsory share, intestate succession applies. If, on the other hand, the deceased spouse has made a holographic will and has disinherited you, respectively stripped you of your compulsory portion, you will receive nothing based on the law of succession. Does this come as a surprise for you? Please review your existing contract of inheritance. Should the preference of the surviving spouse or partner continue, even if a divorce or dissolution proceeding is pending, instruct so accordingly. Is a divorce imminent? Seek advice in good time on the consequences under inheritance law, among other things. I look forward to supporting you fulfilling your personal and last wishes to have a peaceful distribution of your assets. Please contact me for a consultation. And in order not to miss any news or insights, please follow me on social media. Thank you.